Welcome to the first installment of the new Labor and Workforce Continuing Education Series. My name is Matthew Piesold, and I'm a Labor and Workforce Specialist stationed out of Kansas City. This new webinar series represents an outgrowth of past collaborations between MU Extension's Labor and Workforce Development and the Department of Labor. In the past, the Department of Labor has been graciously served as a guest speaker for the Labor Law series hosted out of St. Louis and Kansas City. Today, I'm here to welcome Cassie Robinson, JD, from the Department of Labor. Over the course of the next 2 months, we will offer a series of webinars that will prepare your business, agency, and organization for its legal obligations and responsibilities, and we will connect you to the resources and experts that can help you navigate these complex employment obligations. I'd also like to announce that the MU Labor and Workforce Development Program has applied for continuing legal education credits with the Missouri Bar, and we are pursuing other continuing education avenues. Once these topics have been approved, one will be able to purchase the CEs from the same registration portal that you use to register for this webinar. And for a final housekeeping note, I want to inform you that this presentation will be recorded, but will be stopped for the question and answer section. Please post your questions in the chat feature or save your questions to the end of the presentation. I would now like to turn it over to Kathy Robinson and ask her to formally introduce herself.
Good morning. My name is Kathy Robinson, and I am a benefits advisor with the Employee Benefits Security Administration of the U.S. Department of Labor, and it's my pleasure to be here today to talk to you about Cobra compliance. Thank you very much for taking your very valuable time to attend this today. Normally, we like to do these in person, but obviously with COVID-19, we are doing everything virtually, which has its drawbacks and its positives, as I'm sure you're aware. That being said, I apologize. In my screen, there appears to be some kind of a glare. I've taken efforts to try to eliminate that, so I apologize. Hopefully that won't be the case in the future. I've been an attorney and mediator for 25 years. I received my law degree at the University of Missouri, Kansas City School of Law, and a Master of Arts degree in conflict resolution from Antioch College, the McGregor School. And I have been a benefits advisor for 13 years. And just briefly, I'm going to tell you what a benefits advisor does in case we can be helpful to you in the future. We staff a toll-free line. We have 10 benefits advisors that cover 11 states, but rarely is there a wait. And so that's helpful for you to know, I hope. We do that 8 a.m. to 4:15 Monday through Friday, Central Standard Time. So if you have any questions, you're welcome to call us at any time. At the end of the presentation, the slides have information about how to access our website and publications on our website. So we answer phone calls on the toll-free line. I'm going to give you my personal information also so that you can contact me if you like. My favorite part of my job is to do these outreach presentations to help educate plan administrators and fiduciaries, et cetera, plan sponsors about how to be compliant with the law. And if you are affiliated with any other nonprofit organizations and would like for me or someone else from our office to come out to do one or more presentations, don't hesitate to contact me. My contact information, my direct dial phone number is 816-285-1874. And my email address is robinson.kathyj@dol.gov. So that's robinson.kathyj@dol, as in Department of Labor.gov. So we handle toll-free calls. We also help participants in addition to helping fiduciary and employers and unions and plan sponsors, plan administrators, third-party administrators, other service providers, et cetera. We also help participants resolve disputes regarding ERISA, which is the law that we have jurisdiction over, and the laws underneath that that we have jurisdiction over, one of which is Cobra. ERISA stands for Employee Retirement Income Security Act. Cobra, as you can see from this first slide, is the Consolidated Omnibus Budget Reconciliation Act. And thank you very much for holding your questions until the end. You're welcome to put them into the chat box beforehand, but I won't be addressing them until the end, partly because very often I'm going to answer the question later in the presentation, and also it helps me manage our time together today. And next Monday, on August 3rd at 11 o'clock also, we will be doing a presentation regarding what employers and fiduciaries and unions need to know about relief provided to participants with regards to Cobra premiums and payments, and also with regards to special enrollment rights under group health plans, et cetera. So you might want to attend that one in addition to the other presentations that we'll be offering in the future. So let's talk about Cobra. One of the things that I wanted to let you know is that I try to think carefully about the audience that I'm presenting to when I create presentations. Today's presentation is basically making sure you have a thorough understanding of the basics of Cobra, when it applies, when it doesn't apply, what the different aspects are, and it gets fairly detailed. Most of the rest of the presentations will probably be more geared towards people with more experience with employee benefits. But I try to appeal to the full gamut of people who might be listening. So if you have a great deal of expertise, you might find this a little basic. If you're brand new to Cobra or don't have much experience, this will be ideal for you. If you're somewhere in the middle, I certainly think there's some information in here and hope that you will find quite helpful today. So let's go ahead and get started. Okay, basically Cobra amends ERISA, the law that I just explained we have jurisdiction over. We share jurisdiction with the Department of Treasury, which is the IRS, and the Internal Revenue Code. And for those employers we don't have jurisdiction over, such as government employers, the Public Health Service Act provisions, they have their own Cobra-like provisions. So what is Cobra continuation coverage? Basically, it's the opportunity to continue the health insurance that an employee had once they are no longer eligible for the group health plan as an active employee. And this also applies to their beneficiaries. They're not only the employee, but the spouses and the dependents. But there has to be a qualifying event in order for someone to be eligible for Cobra. And a qualifying event would be something such as termination or reduction of hours, which causes someone to lose eligibility for the group health plan for the employee and beneficiaries. But with regards to the spouse or the dependents on the plan, a qualifying event would be something like divorce or death of the covered employee. Who is entitled to Cobra? Basically, this means what individuals will be entitled to Cobra, what plans are subject to Cobra. So someone is entitled to Cobra if their group health plan is subject to Cobra, and we'll go over which plans we have jurisdiction over, basically, meaning that they are subject to Cobra, and which plans we don't. So it has to be a plan to which Cobra applies. There has to be a qualifying event, and I'll go over what a qualifying event is in more detail later, and also at least one example of a situation where people sometimes think they're eligible for Cobra, but since they don't have a qualifying event, they're not eligible for Cobra. Or they have to be a qualified beneficiary if they're either as the employee or a beneficiary of the employee under the plan. Plan subject to Cobra. This would be the federal Cobra law. Sometimes people call us and they think we are Cobra. And so we explain that no, we are the Department of Labor Employee Benefit Security Administration. Cobra is a federal law that we have jurisdiction over. And which plans are subject to the federal law Cobra? Well, one, it has to be a group health plan, can't be individual plan, has to be sponsored by a private sector employer or a union, and it has to employ at least 20 employees or full-time employees or part-time equivalent in over half of the previous calendar year. So we look at the previous calendar year to determine the number of employees to see if plans are subject to the federal Cobra law. Plan coverage that is subject to Cobra. What constitutes a group health plan? This is basically an arrangement established by an employer or a union to provide employees or their families with medical care. It can be insurance, it can be an HMO, it can be something that we call self-insured, where the employer basically uses, or the union uses, their assets to cover the claims that come in under the plan. The type of medical care that this kind of coverage would include would be physician care, hospital care, surgery, other major medical benefits, prescription drugs, dental, and vision care. And you might be thinking, well, obviously that's what a group health plan would cover. But the reason that we go over these specifics is that we have, basically Cobra applies to, and we have jurisdiction over, what's considered a major medical group health plan. If it's a limited benefits plan that doesn't necessarily offer all of these things, then it would not be a plan necessarily subject to Cobra, or one over which we would have jurisdiction. The plan coverage sponsored by an employer or a union. It includes private sector employers, which means not government employees, any kind of government, local, municipal, county, state, federal government. So my employer, since I work for the federal government, is not subject to the Cobra law that we have jurisdiction over, or an employee organization, such as a labor union. But there may be special rules that come into play there. There are other laws with similar provisions for group health plans sponsored by federal government or state or local government. That was earlier when I mentioned the Public Health Service Act, but those are not ones that we have jurisdiction over. So what does it mean with regards to the plan coverage? The employer must have employed at least 20 employees. The way that we count that is full-time employees would each be one employee. Part-time employees would be counted on a pro rata basis. So for instance, if full-time is defined as 40 hours and there are two 20-hour employees, then that would count as one full-time employee. So it would count as one of the 20 employees that are looked at the previous year. And it would have to be 20 employees more than 50% of a typical business days in the previous calendar year. So most of the time this isn't an issue. However, right now this might particularly be an issue where people are dealing with COVID and their staff may have been reduced quite a bit. And so they may think, well, I no longer have 20 employees, I'm not subject to Cobra. Well, if they had 20 employees that meet these definitions last year, even though they don't this year, they may still be subject to the Cobra provision. So it's important to know that. So who's entitled to Cobra? Basically, there are three requirements that have to be met. The plan itself must be subject to the federal Cobra law that we have jurisdiction over. So like I said, it needs to be a group health plan sponsored by a private sector employer or a union who employed at least 20 or more full-time employees in the equivalent more than 50% of the typical business days in the prior calendar year. There must be a qualifying event, and they have to be a qualified beneficiary, either the employee or the spouse or the dependent. However, they must be someone who was on the plan with the employee at the time the qualifying event occurred. We'll go over that a little bit more here in a little while. So what is a qualifying event? Basically, in essence, a qualifying event causes the individual to lose group health care coverage or to lose eligibility for group health care coverage. And I want to spend just a minute specifying the difference between that, because really it causes an individual to lose eligibility for group health coverage. For instance, say someone goes on Cobra because they had a qualifying event. And then they are on it for 6 months, and it lasts for 18 months typically, which we'll talk about in a few minutes, but they are only on it for 6 months. they would not, if they chose to go off Cobra at that time, they don't lose eligibility for Cobra as a group health plan. They just lose the coverage itself. So they have to lose the coverage and they have to lose eligibility for coverage. So for instance, if we sometimes have situations where the employee turns 65 and they say, I'm turning 65 and I go on Medicare, but my wife is on the plan with me and she's not 65 yet, so she is not eligible for Medicare. So I would like to keep her on the plan as a regular, since I plan to continue to work. I don't plan to stop working. That would not be a qualifying event. The employee going off of the health plan in order to go on Medicare would not be a qualifying event, allowing the spouse to be eligible for Cobra since the employee still works there. The qualifying event itself determines who the qualified beneficiaries are for that event and the period of time that the coverage, that the plan must offer the continuation coverage. Okay, so there's different types of qualifying events, and the best way to keep this straight in your head is to consider qualifying events that applies to covered employees and qualifying events that apply to beneficiaries. When we have a qualifying event that impacts the covered employee, that would also include anyone the employee has on the plan with him or her at the time. So it has to be, like I said, an event that causes the covered employee to lose coverage and lose eligibility for coverage itself. So basically, Cobra must be offered if there is a voluntary or involuntary termination of the employee's employment for any reason other than gross misconduct. Sometimes people think that if they quit, they're not eligible for Cobra, and that's not the case. If they quit, they are eligible for Cobra, assuming they meet the other criteria. Involuntary termination is also a situation under which Cobra will need to be offered so long as it's not for gross misconduct. We don't really go into what gross misconduct is or isn't because we don't make those kinds of determinations. Sometimes it's easy to determine. They'll say for cause, the person didn't do anything wrong, it was a layoff. Those are easy to determine. Sometimes it's something as simple as they didn't show up for work one day. That's not going to be gross misconduct. But when it gets into fine lines between whether or not something serious or more serious is considered gross misconduct, we don't make those kinds of determinations. The employer makes those kinds of determinations. We encourage them to do so based on the advice of their counsel, who presumably would do some case law research in their in the state or whomever has jurisdiction over their situation to determine what courts have found to be gross misconduct for Cobra purposes. But in addition to the termination, where termination can be a little bit confusing because some people consider the word termination to mean firing, and we consider termination to mean loss of employment. The job has terminated. But in addition to the job has ended, the other qualifying event for the employee, him or herself, is a reduction of the employee's hours of employment to the extent that they lose eligibility for being considered an active employee on the group health plan. So if they lose eligibility for the group health plan as a result of their hours being reduced, then that's also a qualifying event, and they would need to be offered Cobra. Okay, qualifying events for the beneficiaries. This would be the spouse and dependent child of the covered employee if the event causes them to lose coverage. Termination of the employee's employment for any reason other than gross conduct. So basically the same events that allow the employee to be eligible for Cobra also allows anyone who was on the plan with the employee at the time to be eligible for Cobra as well. which would also include the reduction in hours, which causes the employee to lose eligibility for the group health plan as an active employee. However, I'll reiterate that this only covers those spouses and dependent child who were on the plan with the employee before they lost eligibility for coverage. So if they have a Cobra qualifying event and the spouse was not already on the plan, or the dependent child was not already on the plan with them at least one day prior to the event that causes them to lose eligibility for coverage, then they can't add that spouse or child to the plan after they lose eligibility for the plan. So basically, they have to be on the plan with the employee for at least one day prior to the whatever occurred that caused them to lose eligibility for the plan. However, in addition to those qualifying events that occur to the employee's employment, there are also qualifying events that are only for spouses and dependent children. The covered employee becomes entitled to Medicare. This is actually more trouble than it's worth, to be honest with you. It is far less than 1% of the time that a covered employee will become entitled to Medicare, which will allow the spouse to be eligible for Cobra. And you can call me, and I'm happy to go over with you the specifics there. It's actually IRS Revenue Ruling 2004-22, if you want to look that up. But it is an extremely narrow situation, basically, that has to occur for that to happen. Unfortunately, in our literature, we don't explain that. People think that because our publications say the covered employee becomes entitled to Medicare, that means that the spouse will be eligible for, or the spouse, or it could also be dependent children, would be eligible for Cobra. So I wish it was clarified, like I'm trying to clarify now, that it is so extremely rare for the criteria to be met in order for that to happen, that I think it warrants some kind of explanation of that in the materials. Oops, I'm sorry. By the way, I don't create the materials. I use materials or cobbled together materials that have been created typically by our national office. So also a qualifying event that a beneficiary would experience would be a divorce or a legal separation of the spouse from the covered employee. This is very important for you to understand and be aware of. It makes sense, but people don't always necessarily understand this. Once a divorce has occurred, that spouse is no longer a spouse, and so they're no longer entitled to be a beneficiary under the plan under active coverage, because basically they no longer meet the criteria under which they're eligible for the plan. So it's very important that participants in particular, but of course certainly plan administrators, understand the importance of notifying the plan if a divorce occurs, so that the plan can send Cobra information to that person. It is either the employee or preferably the spouse that loses eligibility for coverage, or I should say ex-spouse that loses eligibility for coverage, who should take responsibility to inform the plan in writing that the divorce has occurred, and if there is a different address that a Cobra notice needs to be sent to make sure that the employer and the plan administrator or the union has the information about the divorce, the date it occurred, they notify the plan administrator timely with an appropriate address if their address has changed. If they have not notified the plan of a different address or an address change, the plan would send the Cobra notice to the last address they have on file for the person, and it's not the plan's responsibility to find out what that is. It is either the employee or the ex-spouse's responsibility to notify the plan of the new address if there is a new address. And that also would count for dependent children. who may or may not have a different address. However, one thing to keep in mind too is that sometimes dependent children might be at a different address. And so it's very important to make sure that there are opportunities for the dependent child, say they're at college or they move out on their own, since under so very many plans, dependent children can stay on the plan up to age 26, they may not live at home anymore. So it's very important that the plan is rigorous about keeping track of notifications with regards to different addresses for different players involved in one employee situation. In addition to that, another qualifying event that would impact the spouse and dependent children would be the death of the covered employee. So if the covered employee dies, the employer would know about that and would need to send a Cobra notice to the spouse and the dependent children who may or may not be at the same address as each other. However, in addition to what we talked about for divorce and death of the covered employee for spouses and dependent children, you can have a qualifying event for a dependent child, such as they lose dependent status under the plan rules. There are only certain plans that have to allow a child to remain on the plan up to age 26 under the Affordable Care Act. For instance, if it's a grandfathered plan, they may not have to keep the child on the plan up to age 26, and they may have rules such as the child may lose eligibility as of turning age 18 unless the child is enrolled in college. And so there would be specific plan criteria under which the child would be considered a dependent beyond, say, age 18 due to college attendance up until a certain age, and it typically requires some kind of documentation that they're a dependent child. This actually goes beyond the scope of this particular presentation, but I just want to put a bug in your ear that there is a law called Michelle's Law, where there might be a circumstance under which they would qualify for Cobra if they need to take a break from college due to illness for some reason. So if you have a question regarding that, you're welcome to call me or email me or call our toll-free line or send a web inquiry to our website if you want to ask more information about that. And I'll go over how to send an inquiry to our website a little bit later at the end as I talk about resources. So who is entitled to Cobra? Okay, basically one is entitled to Cobra, but they have to meet 3 basic requirements in order to be entitled to Cobra. So it has to be a group health plan subject to Cobra. So when people call me to complain that they haven't gotten a Cobra notice timely, I ask the questions necessary of them to determine that it is what I call a Cobra qualified plan. Is it a private employer or union? Did they have at least 20 or more full-time employees or the equivalent over half the previous year? Is it a group health plan? Sometimes they're calling about individual plans and they're wanting to get Cobra. And so we have to determine that it's a Cobra qualified plan, meaning it's subject to the federal law that we have jurisdiction over. 2, a qualifying event must occur. It must cause an individual to lose group health care coverage based on what we just talked about. And they have to be a qualified beneficiary. Now, I apologize. I just want to clarify that we actually use the word beneficiary in 2 different ways. So I want to clarify that. Typically, we differentiate between an employee and that employee's beneficiaries, which would include the spouse and the dependent children who are on the plan. However, under Cobra specifically, when we say beneficiaries, we also include the employee with that. And so I don't want you to be confused if you see that we use the term to mean both. The good news is that there is no real downside to that other than the fact that it might be a little bit confusing. So basically, a qualified beneficiary is an individual covered by the group health plan on the day before the qualifying event occurred that caused the loss of coverage. The employee, their spouse, or ex-spouse if they got a divorce and there's that's the reason, that's the qualifying event, and their dependents. So like I said, it's essential that they be eligible for Cobra. They be on the plan with the employee the day before the qualifying event occurs. One other thing that I just want to make you aware of, and you may already be aware of this, but just for clarity, is that very often, for some reason, employees sometimes do not understand that once the divorce occurs, that they are obligated to notify the plan that the divorce occurred, essentially because the spouse is no longer eligible as a dependent of the employee because they're no longer the spouse and they need to be offered Cobra. They need to notify the plan in writing of this occurrence with an updated address within 60 days of the divorce occurring. But very often, neither the employee nor the spouse or ex-spouse notify the plan administrator that the divorce has occurred and they've lost eligibility, but they keep the spouse on the plan because it's cheaper for them to do so. Because Cobra is expensive, as we all know, and they think, well, it's family price if I have the employee and the children, and it doesn't cost me anything extra to keep my spouse on here. Why would I go to the trouble of paying a whole separate policy that's so much more expensive typically for Cobra when it's included in the price and I don't pay anything extra for the dependent? Because they just don't seem sometimes to understand that the spouse is no longer eligible for the group health plan as a spouse and it only is eligible to continue to be on the group health plan under Cobra. So sometimes there's a circumstance where it's the end of the year and somehow the employer discovers that the divorce occurred maybe back in February and the group health plan year is a calendar year, January 1st to 12/31. At that point, they have not notified the plan within 60 days of the divorce that the spouse is no longer eligible, and the plan is perfectly within its right to go back and retroactively remove the spouse from the plan as of the date of the divorce, if it's a self-insured plan, or as of the end of the month, if it's a fully insured plan, or whatever their particular rules are with regard to when the group health plan ends upon the event, upon a qualifying event occurring. So that's important for you to know because very often spouses and ex-spouses don't realize that. The other thing is that we sometimes encounter is that plan administrators, whether it's the employer or a third-party administrator, very often have requirements that they only deal with the employee, and everything has to go through the employee. And when there's a situation regarding Cobra for dependents and or the spouse, you cannot require that only the employee do the notification for a couple of reasons. This is practical for a couple of reasons. One is very often, as we're all aware, and I used to be a divorce attorney, so I'm particularly aware, but we're all aware that divorces can sometimes involve quite a bit of animosity, sometimes fights. And so if only the covered employee has the ability to notify the plan administrator or the employer of the divorce and the updated address to send a Cobra notice to for the spouse and or the dependent, the covered employee may not do that because they may want to be spiteful or difficult, or they may just be irresponsible, which certainly is often the case as well, as I'm sure you guys are aware and have dealt with irresponsible people with employee benefit issues. So you have to allow the spouse to provide either the phone, if you allow by phone, or the written notification and update the address with regards to that. And so those are issues that we will handle if a spouse is not allowed to do that, and that's a situation that I recently encountered. So you can't have situations where they have to do so on some kind of a website or through some kind of a database that only an employee can access, or one must have employee information such as a PIN number in order to provide that information. The information must otherwise be available for the spouse to have access to inform the plan administrator or the employer or the union about the fact that they have had a Cobra qualifying event and need to update their information with the plan, and essentially are entitled to a Cobra notice upon that happening. Okay. There's also certain cases involving Chapter 11 bankruptcy of the employer where a qualified beneficiary might include a covered retiree, their spouse or former spouse, and their dependents. A qualified beneficiary can also be any child born or placed for adoption with a covered employee during a period of continuation coverage, and agents, independent contractors, and directors who participate in the group health plan as well. So basically, we talked about a qualified beneficiary was on the group health plan the day before the qualifying event occurred that caused loss of coverage for the covered employee and or their spouse or former spouse or their dependents. And that the qualified beneficiary, if it's a Chapter 11 bankruptcy of the employer, the qualified beneficiary can be the covered retiree, their spouse or former spouse, and their dependents. Okay. So let's see. So we talked about that. Let's talk a little bit about the notice and election procedures that the plan and participant are subject to. Basically, the plan is obligated to provide a summary plan description, or an SPD, to an employee after he or she becomes a participant on the plan, within 90 days of becoming a participant on the plan, or within 120 days, the plan is first subject to ERISA's reporting and disclosure provisions if it's a new plan. Or if it is an old plan that only now, for some reason, becomes subject to ERISA's reporting and disclosure provisions. The summary plan description has to describe the Cobra rights in the plan, including in the plan description, including how to notify the plan of updated information, types of benefits under the plan, the rights of the participants and the beneficiaries. The participant would be the former employee beneficiaries, and how the plan works. Notice and election procedures regarding Cobra. There must be a Cobra general notice, which we provide an example of that you can use verbatim to the extent that it applies to your plan verbatim. This has to be provided to every employee who goes on the group health plan, from the plan to them within 90 days of coverage. Here it says the qualified beneficiary. You don't, if they have a wife and 3 children on the plan, obviously you don't have to send out 5 general notices. It is assumed that you've given sufficient notice if you just supply the general notice to the employee within 90 days of them gaining coverage on the plan. Information included in the general notice: the name of the plan, the address and phone number of someone who can be contacted for plan and Cobra information, the description of their Cobra rights, the explanation of what a qualified beneficiary must do to notify the plan of a qualified event or disabilities. I personally recommend, to save everybody a lot of time and hassle and headache, that you find a way to bold or capitalize or some other way to emphasize how important it is that when someone gets a divorce, that, or even if they age out of dependency status as a child, that they notify the plan that this occurs. And the explanation of the importance of keeping the plan administrator informed of addresses of the participants and family if that changes, but also the beneficiaries if the beneficiary's address is different from the employee's address for some reason, like they're an adult child that lives elsewhere, or they're a ex-spouse that lives elsewhere. Okay, The Cobra qualifying event notices. The employer has 30 days if there's a termination or reduction of hours, the death of the covered employee, or the bankruptcy of the employer. The employer should send out the notice. They have 30 days basically to act. We consider this to be 44 days because basically the employer has 30 days and the plan administrator has 14 days. So it's a total of 44 days that an employer has to send out, to put in the mail to, and date. And the date of the Cobra notice should be the same date that it's put in the mail and it's postmarked as being sent out. For the termination or reduction of hours as the qualifying event, the death of the covered employee, and they've been notified, or the bankruptcy of the employer. If the covered employee or other qualified beneficiary experiences a qualifying event, such as divorce or legal separation, or the child's loss of dependent status under the plan, the employee needs to notify the plan or the employee or someone, anyone, but especially the spouse and a dependent child needs to be able to notify the plan administrator or the employer or the union. And we usually mean in writing, but if you don't require in writing, it can still be effective, but there can be issues later with regards to what actually occurred if it's not in writing. So we typically recommend that you handle things in writing when you can. But they have 60 days to notify the plan that qualifying event has occurred. Okay, so the Cobra election notice, and I'll just distinguish here for clarity purposes. Remember that I said the model notice needs to be sent to every employee within 90 days of them actually getting on the plan when they're initially put on the plan. But the Cobra election notice goes out when a qualifying event occurs and they actually have lost eligibility of coverage and met the other requirements to be eligible for Cobra. So they must be sent a Cobra election notice. And so it says here within 14 days after the plan administrator receives notice of the qualifying event, typically from the employer. Basically, it's a total of 44 days from the later of when the qualifying event occurs or when the loss of coverage should occur that the employer must send out the Cobra election notice. The information in the election notice must include the name of the plan, the address, the phone number, how to elect coverage, what will happen if coverage is not elected, what other coverage is available, or what coverage is available under the plan, and often what other coverage is available, how long they would be eligible for the coverage, and how it can extend for disability or second qualifying event. Premium payment requirements, including due dates and grace periods. If the plan is denying Cobra coverage to an individual who would normally be eligible for coverage or an extension of the coverage, then the plan has to provide a notice of an unavailability of continuation coverage. If the plan is ending the Cobra for the person on Cobra because maybe they didn't make the payment on time, maybe they didn't make the payment at all, what have you, then the plan must send a notice of early termination of continuation coverage. Okay. Then from the date of the notice, which is the date that it is put in the mail to the qualifying beneficiary, they have 60 days to elect Cobra. From the later of the date the coverage is actually lost or the date the qualifying beneficiary is furnished with an election notice, which is the date that it goes in the mail to them. Each qualifying beneficiary can independently elect Cobra. So while usually as an active employee, you don't allow the spouse or dependent children to get on the plan if the employee does not elect to be on the plan, that's not the case with Cobra. because each has an independent opportunity to elect Cobra. If they're on the group health plan and the vision plan and the dental plan, they need to be sent a Cobra notice for each unless you put information for each plan in one Cobra notice. But say there's an employee and a husband and a child on the plan, and they were all on the group health plan, the vision, and the dental. The wife employee could elect the medical, the spouse husband could elect the dental, and the dependent child could elect the vision, and they could just elect as that one person under that plan, or not, or choose only to elect vision for one or two people, or what have you. A qualified beneficiary can waive Cobra and later revoke the waiver so long as it is done before the end of the election period. Duration of continuation coverage. Okay, so typically Cobra is for 18 months. If it's the typical situation where there is a termination of employment, meaning voluntary or involuntary end to employment for other than gross misconduct, or a reduction of hours causing them to lose eligibility for coverage under the plan, then for everybody involved, coverage would be 18 months. There's a caveat at the bottom that they can sometimes have a disability extension, which would be for 11 months if they meet the criteria. So that would be 18 months plus 11 months. And if there's a disability extension, for the period of the disability extension, they can pay a higher premium, and we can talk about that a little bit more. If it's that tiny little situation where an employee becomes entitled to Medicare, then the spouse or dependent child could have Cobra for up to 36 months. But the clock starts ticking not at the normal time frame of when the coverage ends, but beyond 18 months, the clock starts ticking as of the date the employee became entitled to Medicare. So if they're 66 and they became entitled to Medicare at 65, and it's that tiny little situation where they can get an extension up to 36 months. If the employee is 66, they're going to lose 12 months of that 36 months. So I know that's kind of complicated, and that's why before I said if you have that kind of situation, give me a call. So divorce or legal separation, it's 36 months. Death of the covered employee, it's 36 months. Loss of dependent child status, 36 months. An easy way to remember this is if it has something to do with a live employee losing eligibility because of job loss or reduction in hours, it's 18 months for everybody. But if it only involves the spouse and dependent child for some other reason, then they have up to 36 months or less in the case of the employee becoming entitled to Medicare. Okay, the extension of Cobra coverage for disability. For the covered employee, spouse, or dependent child. The disability, and this is crucial, and the wording of this is crucial in the Cobra notice and in the summary plan description and the plan document. The disability must have started sometime before the 60th day of Cobra coverage. So very often they're a year into Cobra and they hear from Social Security that they've been adjudicated disabled. But if it's a situation where the date that Social Security deemed them disabled occurred before the 60th day that they were actually on Cobra, then they would be entitled to the disability extension. The disability must last at least until the end of the 18-month period of Cobra coverage. If the disability ends at the 17th month, they don't get the disability extension. The disabled qualified beneficiary must notify the plan of disability determination within 60 days after the later of the date the Social Security Administration issues the disability determination. The qualifying event occurs. The qualified beneficiary loses or would lose coverage due to the qualifying event, or the date the qualified beneficiary receives the Cobra general notice. So there can be a case where you don't know, or they don't know, that they're going to be entitled to a disability extension because they have not yet heard from the Social Security Administration within the 18 months that they're on Cobra that they are going to be deemed disabled within the first 60 days of coverage. If they already know, if they're already deemed disabled at the beginning of coverage or within the first 60 days, then that makes it easy. There's other circumstances where it's more difficult. But also notice the last one where it says the qualified beneficiary receives the Cobra general notice. That's why it's very important to make sure these notices are sent out. But not only that you send them out, but that you document that you have sent them out, who you sent them to, when you sent them, who sent them, where you sent them, so that you have documentation that that was sent. Because if you don't have documentation that that was sent, they may say they never received it, and that could be an issue for you in terms of notification of disability determination or even other notifications. So the disability extension would make Cobra go from 18 months to 29 months. So it would be an extension of an extra 11 months. Also, say there is a first qualifying event, such as the employee loses the job or has a reduction of hours that causes them to be eligible for the group health plan and lose coverage. So they would have 18 months of Cobra. However, if a second qualifying event occurs, such as a divorce happens or the child ages out of dependency status or the covered employee dies, they can have an additional 18 months. So it can be up to 36 months in that case as well. Early termination of Cobra. You can terminate their Cobra early, meaning before the 18 months or the 36 months or the 29 months, if the premiums are not paid in full on a timely basis. There is one exception to this, which is if they do not make the full payment by less than a significant amount, meaning 10%, you have to let them know that they failed to pay the full amount and the amount that they failed to pay, and give them an opportunity to pay that. But otherwise, if they don't pay it in full on a timely basis, then you can terminate the Cobra. If the employer no longer has a group health plan under which to offer Cobra, for instance, the company goes out of business and lays off all the workers, well, in that situation, they no longer have a group health plan for active employees, so they cannot offer Cobra to people because there has to be at least one active employee on a group health plan for Cobra to occur. If a qualified beneficiary, including the employee, begins coverage under another group health plan, then you can terminate the Cobra. If they become entitled to Medicare after electing Cobra and choosing to go on Medicare, and if a qualified beneficiary engages in certain types of conduct, such as fraud or misrepresentation, to get on the plan, then their coverage, then they don't have to be offered Cobra, or their Cobra coverage can end, or in even some circumstances be rescinded if they engaged in fraud or misrepresentation. Benefits under Cobra. They have the same benefits under Cobra as a similarly situated active employee, same benefits, choices, and services, same rules, same limits, co-pays, deductibles, coverage limits. They must comply with the rules of the plan, the way they file benefit claims, and following the appeals process. The employee or the beneficiary pays for the Cobra. The plan can charge the cost of the employee share while they were on the plan actively, plus the employer share while they were on the plan actively. So they can charge them 100% of the entire cost for them and their beneficiaries or their beneficiaries, plus a 2% administrative fee. However, if there's a disability extension for those 11 months, they can be charged 150% of the cost of the premium. And if they're eligible for a disability extension, that's for anybody on the plan with them, even the people not disabled, or only for the people not disabled, which is an interesting twist. Once they elect Cobra, by filling out the paperwork and putting it in the mail, saying, yes, I want Cobra, they have 45 days from the date they sign it and put it in the mail to make the initial premium payment. And for each month after that, they have to have a minimum of a 30-day grace period for any future premiums. There are other alternatives to Cobra. They can special enroll in a spouse's plan if they have one, or if they have another job with a group health plan, they can special enroll in that, or they get a new job with a group health plan, they can special enroll in that. There's the marketplace, there's state-sponsored programs, there's individual plans. The role of the federal government in Cobra. We have jurisdiction over private sector health plans, certain provisions, the disclosure provisions, sending out the notice and the summary plan description, et cetera. The eligibility of people to Cobra, what the coverage entails, and the payment provisions. There are other laws that sometimes coordinate with Cobra. The Family and Medical Leave Act, for instance, if they're subject to the Family and Medical Leave Act, but they have a reduction in hours causing them to lose eligibility for the plan. Typically, you have to keep them on the plan as an active employee until the end of their FMLA timeframe. HIPAA, they have special enrollment rights onto other plans, like I just said, the employer or the spouse, or maybe if they have another employer, and then USERA for people in the military. Resources you should know about. I've already told you about the toll-free line. Our toll-free number is there. Our website is there, which is where you can go to file a web inquiry if you prefer to do it online rather than call. And then there's also resources with regards to FMLA, because our wage and hour division has jurisdiction over FMLA. We don't. Other resources for military folks, USERA, for people who work for the public sector government, places to go there, and for federal employees. Other resources, publications that you should know about that are available on our website, and employer's guides, group health continuation coverage under Cobra. All of this information is in that booklet. There are 2 Cobra model notices, one the general notice, one the election notice. Do not send the election notice, which is when they have a qualifying event, verbatim off the website. The model notice you can. The election notice has to be individualized for that person and their situation. There's also on our website the reporting and disclosure guide for employee benefit plans and the compliance assistance guide, health benefits coverage under federal law. Okay, does anyone have any questions? And I know our time's almost up, so I'm happy to stick around.